morning to all of you. My name is Sultan Abdulla, and I am the managing partner of Sultan Abdulla and Partners, a law firm based in Doha, the state of Qatar. As a full-service law firm, we are often asked not only to represent our clients in litigation and arbitration matters, but also to advise on corporate and commercial issues, including income tax liability and structuring. Today, I will be speaking to you about taxation in the state of Qatar. By way of background, in 2009, the state of Qatar overhauled its tax system in order to create a more competitive tax environment and thereby incentivize foreign investment, while at the same time generating income by capturing previously untaxed activities. The 2009 law provided for a corporate tax rate, introduced a withholding tax on payments made to non-resident entities, and generally maintained the previous 35% tax rate applicable to income derived from petroleum operations, unless the relevant contract provided otherwise. More recently, a new tax law was introduced in 2018, which replaces the 2009 law, and while it doesn't implement the same level of reforms provided in the previous law, the new law and its executive regulations, which were very recently issued in December 2019, do introduce some significant changes to the tax system in Qatar. As an initial point of discussion, it is important to note that Qatar has several commercial jurisdictions with different tax rules and regulations. The main tax jurisdiction I will be discussing is that of the state, which is the onshore jurisdiction. The state tax system differs from the tax systems implemented in the special economic and free zones, each of which I will discuss later in more detail. So I will start with the state or onshore tax system. The primary piece of legislation governing tax in the state is law number 24 of 2018, which I will refer to as the income tax law. According to the income tax law, a corporate tax rate of 10% is applicable to income derived from sources in the state, which includes, among other things, income derived from business or service activities carried out in the state, and contracts wholly or partially performed in the state. This 10% tax rate applies to the net taxable income of resident corporate entities in the state. However, certain types of income are subject to exemption from tax. For example, personal income is not subject to tax. Companies that are resident in the state or that have a permanent establishment in the state are subject to tax. A company will be considered as being resident in the state for the tax purposes if it was established pursuant to the laws of the state, has its headquarters in the state, or its main or actual management center is in the state. Further, a permanent establishment is defined as a fixed place where a taxpayer conducts all or some of its works, but can include the activities of a non-resident company that are exercised through a person in the state acting in its name or in its behalf, unless that person is an agent with an independent status. However, the income tax law regulations have expanded the definition of permanent establishment to also include the following. One, a construction site or project or supervisory activity associated with the project if the site, project, or activity lasts for more than 6 months in the state. And two, a service providing activity including consulting services by employees or other users if the activity continues within the state for one or more periods totaling more than 183 days in any given 12 months. Another important change introduced by the income tax law relates to the withholding tax. Under the 2009 law, there were two groups of payments to non-residents which were subject to either a 5% or 7% withholding tax. The income tax law now has a single withholding tax rate of 5% applicable to the following payments made to non-residents: the gross amount of royalties, interest, commission, and amounts for services wholly or partially performed in the state and not through a permanent establishment. Furthermore, in determining withholding applicability, the 2009 law relied on a performance test. In other words, where the services were performed. However, the new tax regulations suggest a wider applicability of the withholding tax based on a consumption test, meaning the focus is on the place where the services are used, consumed, or utilized, regardless of whether they are carried out in whole or in part in the state. In addition to these changes, the income tax law regulations introduced new transfer pricing requirements, and losses may now be carried out forward for a period of up to 5 years. There is no stamp duty in Qatar, but a 5% customs duty applies to equipment imported into Qatar on a permanent basis. In other words, equipment that is not re-exported prior to the expiry of 6 months of being in the state. One particular topic that has been looming on the horizon for a while is the implementation of the value added tax. Qatar, along with other members of the GCC, the Gulf Cooperation Council, adopted the Unified Agreement for Value Added Tax, which was to be introduced in 2018. VAT was to be levied on the supply of goods and services at a rate of 5%. Each GCC state was to issue legislation on VAT along with detailed procedural and compliance regulations. Unlike some of the other GCC countries, Qatar has not yet implemented VAT, and although it is rumored that it will be coming soon, there is no certainty as to when that might happen. I will now move to talk about the special economic zones and free zones. The Qatar Financial Center, QFC, is a separate economic zone with its own set of commercial rules and regulations that differ from those of the state. Unlike the Dubai Financial Center, the QFC is a quasi-onshore jurisdiction in that entities licensed by QFC may also conduct business in the state without additional licensing. The QFC applies a flat 10% corporate tax rate that applies to all licensed firms. The QFC tax regulations provide for a concessionary tax rate of 0% for reinsurers, captive insurers, and businesses that are Qatari owned, where at least 90% of the company is owned by Qatari nationals. There is no withholding tax in the QFC, and tax losses may be carried forward indefinitely and set against future profits. The second area I'll touch upon is the QSTP, the Qatar Science and Technology Park. The QSTP, which incidentally my firm helped establish and draft its rules and regulations, as well as some of its enabling legislations, is a special technology zone. Membership in the QSTP is primarily limited to companies whose primary focus is on research and development. Companies established or registered in the QSTP are not subject to tax. Moving on to the Qatar free zones, Qatar has contemplated the introduction of free zones since early 2005, and my firm has assisted in the drafting of the investment free zone law in 2005. For various reasons, the free zones project was put on hold. But in September 2019, the first free zone in Ras Bufantas came online. Although the Qatar Free Zone Authority is expected to issue specific regulations governing the operation of the free zones and addressing issues such as tax, only 2 regulations have been issued thus far. Regardless, it is expected that companies established or registered in the free zones will enjoy a 20-year tax holiday and will not be subject to custom duties. I hope this information has been helpful. Obviously, issues relating to tax are complex and cannot be addressed comprehensively in a presentation such as this. I hope I was able to give you a high-level view of the tax system in Qatar. Thank you very much.